you've got a junkyard dog for a lawyer who we respect very much.
That's the one he's seen, the person is seen at some point.
Can I make my argument, Counselor?
No, I thought you were emailing, yes.
I am, but let me
while
at
you're
least make
emailing,
my argument.
I wanted to give him a synopsis of the case.
Let me make my synopsis and then I promise you I'll let you respond.
250-7650. Yes, he's a gentleman, you wanted him enrolled in IOP and SOP. He doesn't live nearby. So Nathan said if he does that, then he can do a PTI, but he has to do all that first. He has to provided my office with the documentation and he's been enrolled. It is going to take some time, as the court knows, but you wanted me to come once he got in so we can get another reset.
So do you have proof of?
Yes, sir.
In the
Yes, sir. Yes, sir. I can show
So
you.
just make sure, if you don't mind showing this to Tori, so we can just verify it's the proper one, and then
Yes.
we'll set you off,
Absolutely.
4 weeks, just to make sure he's
Sure.
in compliance with it,
Yes.
and we'll come back and then.
Yes, sir.
How long is the IOP?
Which providers?
Let me look at the email, sorry.
It's 3 to 4 months.
Right. So what we'll do, Herman, is depending on how long it is, we'll do like a halfway check-in,
Right.
just to make sure that he's doing well.
It is with Better Journey.
Are you familiar with that one? No? Okay. We'll sit you halfway,
Sure.
and then we'll reassess.
Ramos is on your docket today, Judge. He's a Spanish speaker, but I understand he's
Is that
over.
him?
Yes, yes. But he speaks, but I want to address something. His employer's here with him. They own an event company. Forget the lady on the right. And he's a driver for them. So I was hoping one or two things that with the interlock is just on his personal vehicle, as long as the employer, which she's here to vouch for him, he can drive that vehicle without, as per kind of like he doesn't have a commercial license, but under the occupational license, the statute allows it. But I was hoping the court either does something like that or just put a portable, which is more intrusive than the interlock itself.
I'm okay with that, Herman.
Okay, thank you. Okay, and I'll wait to
Personal, and then on the scram on the other one, so we know he's not, while he's in the other one.
scram. Can that be agency paid to scram? Sure. Okay, cool. Okay, so a portable and a scram. Okay, thank you.
And we'll pay for both.
Okay, thank you. And I'll just wait for the interpreter. And then, so he is allowed to drive as long as, yeah.
I mean, he has a
Yeah,
license
he has
and
a-
insurance, right?
Yes, sir. Yes,
You have insurance? Okay.
yes.
Council.
Oh,
Do
sorry.
you see that, Michael? Do you see who we're talking about? It's Ramos Amaya. So essentially, he wants the interlock only on the personal, not on the work, but we'll also do a scram to ensure that while he's, at no point, he's consuming.
But how are we gonna supervise him driving that vehicle, Judge? We don't know if he's, there's no possible way that the court can supervise and find out if he's intoxicated or has alcohol.
Scram's on his leg at all
On
times.
his
But
leg.
we can't tell if he's gonna drive, Judge.
He is gonna drive. He's gonna drive his personal
understand,
vehicle
but
and the vehicle owned by his employer that she's here to vouch for the court, that he's not going to be driving with any alcohol in his system.
You can't vouch that he's not driving, he's not gonna have alcohol in his system, Judge. The only way we can properly supervise.
I'm not asking pretrial to vouch for it. Her employer, which is a reputable citizen, and she's here and here to
And
tell
that
you.
vehicle is he driving for? What does he do?
It's an event company, so it's those trucks that, they bring, the tents and everything for events.
I would be against it, Judge, just because we can't coincide the scram to when he's driving the car. So he could drink a beer and drive and the car would activate and we would have no idea.
It's
He would get a
excessive what they're asking for on
BVR
a first
eventually.
offender.
Let him-
I'm sorry, I thought he was done. Sorry.
He would get a BVR eventually, Judge, but there's just no way that the court can properly supervise him and ensure the safety of the community if we do it that way. I understand counsel's position, but I would disagree.
This is his livelihood, Judge. I mean, and he's such a great employee that it's very rare, as you know, when an employer comes
Absolutely.
in, that's how.
So, but why is it that the device can't go on the work vehicle?
Because it's a company vehicle, it's a,
It's a vehicle, though, right?
Yes, but-
Theoretically, it could, right?
but other employees drive that as well, Judge. I mean, it's just to put that burden on the employer is a bit excessive to have, that lady is a small business owner to incur that. And then you're gonna have other people driving it, and it can come back to Mr. Ramos's DVR as well.
No, because
No,
it takes your picture.
Yeah, but you
So,
still-
if someone else, is consuming, which they shouldn't while they're working regardless.
No, I
right?
understand, but it's just excessive where he's gonna have the scram and he's gonna have.
I'll take it off.
I'm sorry?
I would take it off. I wouldn't, there's no need for a scram at that point if we put it on the work vehicle, right?
So,
I don't know, Tommy, look, we're putting the cart before the horse because we haven't even found PC on it yet.
no, okay, I mean,
Let's really address it, and then I can always talk to her and figure out, there's always a solution that can be worked, always.
I'll just wait for the interpreter. John Ramos again. I don't know if you've taken a look at the cases that the state provided. They're very distinguishable, both of them. On one, the Prego case, someone actually sees the driver driving at some point, and then.
I've read about 17 different cases.
Right, and then the second one that the state has provided, the driver self-admits that they were driving at some point, and in both cases, they have the seatbelt on, and there's other evidence of driving and operation, which is distinguishable. In this case, there's no facts that he had a seatbelt on, or he was seen by anyone driving, or he ever admits to driving. So their reliance on those cases are unfounded because it doesn't fit this fact pattern that we have before us today.
So Judge, the first case that I'll refer you to is Prego versus State, which in that case,
Do you email it to me by chance?
I can send you an email right now, Judge.
That's the one the person is seen at some point.
Can I make my argument, Counselor?
No, I thought you were emailing, yes.
I am, but let me
while you're
at least make
emailing,
my argument.
I wanted to give him a synopsis of the case.
Well, let me make my synopsis and I promise you I'll let you respond.
I was in back reading, I must have read like 17 cases. God, I don't think that there was any case that supported your position. I must have gone through at least 17 or 20
Well, they have to
cases,
prove it's a totality of circumstances. Just behind the wheel is not sufficient. They have to provide. Okay.
So let's go to Kennett versus State, Judge. I sent you an email. Did you receive it?
Okay.
Okay. So in that case, I'm reading just word for word from the case. Courts interpret, quote, operation of a motor vehicle very broadly, and they cite Prego versus State, which is an appellate case. They cite Smith versus State, which is an appellate case. And they say, quote, while driving does not involve operation, operation does not necessarily involve driving. So we have to prove operation of a motor vehicle. Operation does not necessarily mean driving. It states any action that is more than mere preparation towards operating a motor vehicle falls under the definition of operating. So in this case, we have
Does the fact that you turned the keys onto the car,
is enough, Judge.
That's his opinion. There's no case law that
That's
says
what the
that.
case law literally
You're saying
states.
mere
word
preparation.
for
like
word.
conspiracy, right?
Yes.
The law
Or
of conspiracy
law
is, it has to be more like.
So
an
what did he
overt-
do other than start the vehicle? There's nothing more than mere preparation. It
And
was a
that's
hot
what-
day, and the Prego case, people see them, they have the seatbelt on, which is more than mere preparation. They don't show the seatbelt on. In the other case, the Houston case, it self-admits that they were driving. In this case,
Yeah, that's right. We're not gonna, if there's a self-admission, that's.
right, and those
now we're-
are what they relied on. The two cases, on the second case that he's quoting, or he showed you on the site, that defendant self-admitted, and there was also other evidence
Have you
beyond mere preparation.
You found any case law to support the position though?
Well, what position? It's their burden that there was more than mere preparation.
No, but I've asked you to see if you, because I went in back and I literally read through 20 cases
Yes,
and I can't find any case that supports the proposition that that's not operating.
well, what they have to show is more than mere preparation. Having your vehicle on by itself is not beyond mere preparation. That is just mere preparation. They have to show either they had a seatbelt on, or the car was in neutral, or something beyond just in the car getting AC on a hot day. I mean, that,
If you can.
And Judge, there's no, yeah, right.
And, you know,
Right.
I'll certainly look.
I mean, that's what everyone, our legislatures tell us. If you feel like you should just stop and pull over, and that's what he did. And then someone comes at a later time.
There by your admission.
No, I'm not, because if you stop, turn off your car, and then you get hot because you're in a hot vehicle, turn it on, that's not operation. That is not beyond mere preparation.
Where are you getting that from? How are you saying that's not operation? What is your citation for that?
You just stated in your case law that you have to prove more than mere preparation.
Okay,
My opinion, my
Love
statement is, all you have shown is mere preparation. That's it.
but
You
you
haven't
have,
gone beyond mere
but to
preparation.
be clear, you don't have any legal basis for your opinion.
Yes, your opinion is right there when you said you have to, it's a totality of circumstances and you have to show more than mere preparation.
And I think the fact that,
There is no case law that says that.
find me something.
Well,
different.
that case says it. That case says just turning on your vehicle, you have to show more than mere preparation.
That's not what it says. It doesn't
You
say
read
just
that.
turning on your vehicle is not enough. That's not what it says.
Is that Prego?
This is Kennett versus State.
And then that case is also
I'm
distinguishable.
gonna read it exactly what I read to you just a couple of minutes ago, Judge.
Okay.
Courts interpret operating a motor vehicle very broadly, and they cite multiple cases. While driving does not involve operation, operation does not necessarily involve driving, stating that any action that is more than mere preparation towards operating a vehicle falls under the definition of operating. So any action that is more than mere preparation towards operating a vehicle, that does not state that doing this with a key and turning on the car is not more than mere preparation. Our position is that that is more than mere preparation. You've put the key in your car, you've activated your vehicle. That is more than mere preparation. You're attempting to operate the motor vehicle. You don't need to be seen driving the vehicle to satisfy operation under this case.
I want to be clear. I'm not saying that it has to be seen, but they're stating exactly conversely what I'm saying. You're asking me to show you where just putting on the key is not operation. Well, I'm asking for them to prove just putting on the key is mere preparation, because they're stating a case where the defendant admitted to driving, okay, in that case. And that is in the facts of the case. And that's what the court relied on, that in addition to this law, that he admitted to
You're
driving.
saying in Kennett,
Yes, that
Admitted
defendant
operation?
took the stand, admitted that at some point she operated the vehicle. In the Prego case, someone saw that person driving the vehicle. Then they saw him at a later time.
They admitted to driving at an earlier time.
Yes,
They didn't
yes.
admit to driving then.
Yes, that's
Can you-
correct.
Can you point to me to at least one case that shows me where they have found it not to be operating?
No, but I'm also going to state this to the court. Can they show you one case where just having the key in the ignition is more than mere preparation? They haven't shown you that.
I went through 17 to 20 cases, Herman. I haven't found, I looked.
Either way, I bet. Either way, either way. So it's up to the
I
court's
didn't find
discretion,
any, yeah, I didn't find anything to support the position.
theirs or mine.
So let's do this. I'm gonna find it for now.
Okay.
Go back, do some research.
No, there isn't. I'm very clear on the law. They have to show more than mere preparation. And they haven't in this case.
According to the case law, they have that.
No, I disagree, Judge, because because they haven't shown that starting your car is more than mere preparation.
I appreciate it, but the law says differently, you know? Come up, Mr. Ramos. Oh, do we have a translator or no?
And then we have the second issue, Judge, where we have a disconnect about, he
I know, and I'm gonna bring her up to talk about it.
Yeah, I mean, that's just ridiculous on a first-time offender to have where he did the right thing, even in the courts, pulled over and safely, and it was not a danger to anyone in this case, to have two interlocks put on one on a personal vehicle, on a commercial vehicle, where our legislature stated for an occupational license where someone's already been convicted, they can have it just on their personal vehicle and not on a commercial vehicle they're driving. So it's just excessive to have two interlocks, especially where she has multiple vehicles that he's gonna have to drive, where he's the manager of the events place, and he's all over all the time driving multiple vehicles, multiple trucks for him. And she has a strict policy of no alcohol.
Let me get the translator.
Sure.
I'm approaching for a recent on Valdez. The case is old, however, we don't even have an offer as of right now. The state wants to evaluate it. And the recall was just completed as of yesterday, so.
It was clear as trial. It says as of 9:30, you had an offer.
Well, no, I don't have an offer. And like I said, the recall was just completed yesterday.
Guys, do you have an offer in Valdez?
Judge, this was a 2B case, so even though the offense happened last year, he wasn't.
I get it's, but it's still 190 from the time that he's been arraigned with us.
So we just first were able to make contact with the complaining witness finally yesterday. And I spoke with her and she said that she had just signed an affidavit of non-prosecution with the defense like 2 weeks ago. Defense had not advised us of that. So I just need time to do an eval and see if I can prove it without her. So I just need to listen to the 911 calls.
Do a week. He's got to be here at the next setting because by then it's over 200 days. We got to figure out what we're going to do. We'll give you a week. Okay. And then in the interim, if you can put an offer on the case as well.
Judge.
And then he has an open aggravated assault, same complaining witness as well.
No different.
Okay. All right.
I thank you, Judge.
Yes, ma'am. Ma'am, come up. Okay, Mr. Ramos, I've been
Order in the court, please.
I am going to find that there's probable cause to go forward.
Declarar que hay causa probable para continuar con su caso.
I am ordering you as a condition. of rebuttal. Well, let me ask you this. Are you a United States citizen?
¿Es un ciudadano estadounidense?
No.
No.
Are you in this country with or without permission?
Judge, I always tell my clients that it's not to answer it because you're asking them to admit to a potential criminal.
Okay.
Yes.
Ok, está bien.
I want you to understand
Quiero que
one thing.
entienda de que
Not in
una
this
cosa es si
country
no
with
está en el país
permission.
con permiso.
You go to jail
cárcel.
and immigration finds you, they will put an immigration detainer on you and you will be stuck in custody first until this case is over with and then shipped off to immigration. I don't know what your immigration status is, but if you're not in this country with permission, be very careful. Do you have a Texas driver license?
Licencia de conducir de Texas.
Do you have liability insurance in your name?
Yes.
Okay, you may continue to drive, but I am ordering you not to consume alcohol or illegal drugs. I will randomly test you. If I find that you're consuming alcohol or any kind of illegal drugs, I will put you in jail. You will not get any more PR bonds. Now, I will order you to obtain an interlock that you're not allowed to drive any vehicle that's not equipped with an ignition interlock on it. Your counsel has asked me not to put one on in the work vehicle, but understand that could be a huge liability on your part. If there's an accident and they learn of that he has an open DWI, it could be potentially disastrous to your business. So you need to consider this when you're out there, especially if he's driving and he has an open DWI, it could be very disastrous.
Are you saying that he's allowed to drive one of her vehicles without an interlock?
I know that you're against
Yo sé
this,
que usted
right?
está contra eso.
What I will do is I'm
Lo que
also
haré es que también
scram monitor on your ankle, so I know that you're not consuming alcohol at any time, and I will not put it on the vehicle,
Thank you.
okay? But I want you to understand, these machines are extremely finicky, so you better darn well know anything that you put in your body before, because I don't care what it is, if it's a tequila lollipop, if it's NyQuil, if it's hair dye, if it's isopropyl alcohol, if it's Jesus comes down and tells you to break bread, I don't care what it is. The slightest, faintest, most remote positive alcohol, you will land
Pero
in
pues que
custody.
tenía otra vez.
Do you understand? Be careful, especially with your insurance, because if insurance knows that if your insurance doesn't know that he has an open DWI and it gets into an accident, they may deny liability. So, you need to really put everyone on notice because it could be a very big issue.
Puede ser otra, pero-
I'll make that phone call.
Sí, puede ser ese.
Now, good job on having a lawyer. You've got a junkyard dog for a lawyer who we respect very much. It is your responsibility to stay in touch with Herman. He will tell you if and when you have to come back to court.
Sí, cuando sí tiene que regresar.
Herman tells me that he can't get a hold of you because you're playing games, I will issue a warrant for your arrest. Just stay in touch, do not pick up any new cases, and don't consume alcohol.
No,
Do you have any questions?
No.
I will also pay for the devices so that there are no issues, Herman.
Okay, thank you, sir.
Do you have any other issues? that
No,
you
sir,
want?
not at this
Okay.
time.
All right. With that, we're done.
Thank you.
All right. Gandhi.
Judge,